All right, well, we'll get started, everybody. Got a fair few people on, and anyone else will join as we go along. So hi, everyone. Welcome to the fourth masterclass in our 2024 Law and IP series. So today we will be doing an introduction to contract law. My name is Sruthi, and I'm a PhD student within the IP team in the law school. And today I'm hoping to provide you all with an introduction to contract law and hopefully how it is not only relevant, but I guess quite important to you in your lives as well as your careers. I'm hoping to take you through the more legal side of contracts at first, I guess to introduce the terminology as well as the legal formalities that surround the contract process, from creating all the way through to breaching and terminating a contract. But then in the second half, hope to make this all a little bit clearer and easier to understand by explaining how these things play out in contracts that you have already come across and no doubt will see again. So before we get started, I would just like to acknowledge the traditional owners and their custodianship of the lands on which we are all meeting from today. I would like to pay my respects to their ancestors and their descendants who continue cultural and spiritual connections to country and recognize their valuable contributions to Australian and global society. So what is a contract? So the key part of a contract, or the way that we'll be speaking about it today, is that it is a legally enforceable agreement between two or more persons or legal entities. So when we say legally enforceable, it's legally binding on the parties, as courts can intervene in order to enforce the contract. And there are remedies and repercussions for not behaving in accordance with the contract. So a contract generally comprises of an exchange of promises. So this will be could be services for money, services for services, goods for money, etc. And as I said, it's legally enforceable. So who can enter into a contract? Individual adults. So all of us as individuals are likely to be able to enter into a contract. There is a capacity requirement, but there's no need for us to sort of go into the technicalities of that today. Minors can, but only for necessaries. Corporations can contract, so they are a legal entity, so that's all companies, small or big, can contract. Governments are legal entities that can also contract, as well as incorporated associations. So incorporated associations can cover a huge breadth of different types of legal entities, from not-for-profits to body corporates and so on. So things like the university would most likely fall under that. So every contract, whether it is simple or complex, will be considered legally enforceable, provided it incorporates these essential elements. So I've given the legal names or legal terminology for the events that produce a contract. So this is offer, acceptance, consideration, an intention to create legal relations. And then I've sort of joined the last ones together, being certainty, completeness, and legislative requirements. But as we go through the next slides, I'm going to explain each of the elements individually and what they entail. If any of these elements happen to be missing from a contract, it can make a contract invalid and unenforceable. So again, I mean that the courts will not enforce it, and therefore it is important that we understand each of these elements. So an offer is the first thing in the process. So an offer is a definite and a specific proposal. And if it is accepted, will create the legally binding agreement. So therefore, it becomes very important to know what constitutes an offer and what does not. It's usually an expression of willingness to contract on specific terms, and it's capable of acceptance by the person to whom it is addressed. Key point to note that an offer can be made to an individual, to a group, or even to the world at large. An offer, though, is not the same as invitation to deal or negotiate. So the language sometimes that the law uses is that is called an invitation to treat. That itself does not create a legally binding agreement if there is some sort of acceptance on the other end. And when I talk about an invitation to negotiate or an invitation to treat, the most common examples that we will come across are sort of advertisements, catalogs, and price lists. Those are inviting somebody to come and negotiate. And if they take someone up on that advertisement, then the next step could constitute an offer. So that's quite key to note. And just because you've made an offer, that does not mean that a contract will come immediately. There are ways to deal with your offer if you decide you don't want to, or there are things to put in the offer to give yourself scope to maybe back out. So an offer can be terminated in a number of ways. You can obviously withdraw it before acceptance takes place. It can be rejected by the offeree. You can put a time period in it, and often that is the case. That offers come with time periods in which they need to be accepted, and that can lapse. It can be terminated by death of the offeror, but it can also, offers can contain specified conditions and therefore terminate if those conditions are not met. So provided we have had a offer that has been made and correctly been made, the second element essential to creating a binding contract is acceptance. So an offer must be accepted in order for a valid contract to come about. And acceptance is sort of termed as a meeting of the minds, but this just means that there is a consensus where there is an unequivocal or unambiguous statement of conduct that agrees to the offer and can be taken as parties agreeing to the shared terms of a contract. Acceptance has to be communicated to the offeror, and it's upon that communication that a contract is formed, provided all other legal requirements have been met, which we will come to in a second. Important to note that if you make a counteroffer, that is not necessarily acceptance, or that does not mean that the other party needs to accept that and that forms the basis of your contract. A counteroffer will restart the whole process, and provided that your counteroffer is valid, that will be an offer again, and you go so on and so forth again until that is accepted. So we then have consideration, and consideration is a legal term that is just used to describe the benefit that each party to a contract receives. So this is most likely going to take the form of payment in exchange for goods or services, but it doesn't need to be money. It can be anything of value that you obtain as part of a contract, so equipment or work. It can be anything that is stipulated by the promisor, provided it is not illegal. The consideration, though, must have value in the eyes of the law, which generally is taken to say that it must exist. So you can't say that consideration will be something that may or may not come into existence in the future. There are a lot of funny, awkward rules within the law about consideration, but it's generally semi-straightforward to see where the consideration lies. And it, like I said, it doesn't have to be much. It can be something tiny. And you usually get people making quirky anecdotes about consideration being like a gold coin or $1 or something, and that being enough to get a contract on foot. So the next one we have is intention to create legal relations. So the parties involved in entering into the contract must intend to create legal relations. And although we're using the word intention here, it describes what it is that would objectively be conveyed from what was said or done. So we're not actually going and searching for uncommunicated subjective motives or intentions of the parties. And if we were trying to go into an assessment of their intention to create legal relations, we would be looking at an assessment of the facts in each case and the state of affairs. So this might include things like the subject matter of the agreement, the relationship between the parties, surrounding circumstances, if it was two corporations dealing with one another and, doing things like an offer and acceptance, an intention to create legal relations would be quite obvious and taken quite easily from the circumstances. But there are no universal prescriptive rules on this, just because circumstances of each assessment might vary. However, parties can make express statements to say that they do not intend any of their agreement to give rise to legal rights and obligations. So you might have negotiations taking place between different parties that are conducted under a stated understanding that these are subject to contract, so subject to contract in the future. So any common positive intention not to contract will be respected. And so finally, we have certainty, completeness, and legislative requirements. So the terms of a contract need to be certain and complete with regard to all of the essential terms. And when we say essential terms, what we mean is terms that without which the contract can't be enforced. So things like the price of a good or the price for services, the contract just won't make sense if you don't include that. The scope of any work that was going to be provided, the identity of any objects that were going to be transferred. So an easy example is that in the contract for a sale of land, the essential terms are likely to include the parties to the contract, the land in subject needs to be adequately identified, and purchase price. It's not actually required that all of the terms in a contract are perfectly certain or absolutely complete, provided their meaning is ascertainable. And important to note that if things that aren't essential terms are slightly unclear or uncertain, that doesn't render the entire contract void. The meaning might be found in other parts of the contract. There might be methods within a contract to deal with ambiguous clauses. Courts might intervene to interpret contract clauses, which we'll come to in a minute. So therefore, or you might be able to sever certain terms, but you won't necessarily get rid of the whole contract just because some terms are ambiguous. However, they need to have the essential terms, and the essential terms need to be certain and complete. And on top of this, any legislative formalities must be complied with. So we'll come to some legislative formalities in a minute. But what I mean is that certain types of contracts or contracts in certain industries have legislation on top of it in which the contract needs to adhere to all those things or include the requirements of those to be valid and enforceable. So how do you make a contract? So contracts can come about in a variety of ways, and these can include things like signing documents. You can agree over the phone. You click an I agree button on a web page, but you can also start to just act in accordance with the terms of the contract, having communicated acceptance. So that's why we say they can be made orally, writing, partly both, and by actions. And also a contract can come about on the back of a number of various different documents. So you can start putting together emails, conversations, and forms, and all of that can make the complete contract. However, as I said, you do have legislative requirements in some areas. So some contracts are only going to be valid if they take a certain form. So in Queensland, as an example, the transfer of land is dictated by legislation that it has to be in writing. So no oral agreements to transfer land are going to be held up by a court. So now that we've sort of looked at the formation of a contract and the steps and the means involved, we'll turn to what is actually within a contract. So some particular terms to look out for and be aware of. So ideally, I guess the idea is that you should be paying attention to all the terms of everything that you sign on to or you agree to. However, if we wanted to concentrate on a few things in particular, you want to know parties' rights and obligations under the contract. So we don't just mean your rights and obligations. You should also be aware of what the other party's rights and obligations are, the obligations that need to be performed and when, payments and their timing, how long the whole contract goes for, if there is a duration on it. And some maybe slightly overlooked terms might be ones that stipulate a particular jurisdiction for disputes to be governed by. So these are called choice of law clauses. So when you might have sort of cross-border contracts, which laws are going to dictate if you have a dispute or you need interpretation of clauses or need the courts to intervene. And also terms that govern how the contract may be terminated by parties. You are generally bound by what you agree to within the contract, whether or not you have read or understood the contract. However, this doesn't apply to situations where there is deemed to have been improper conduct by one of the parties, which we'll come to talk about in a few slides' time. Also, something that might be overlooked is that your contract may allow the other party to vary the terms from time to time, and there could be conditions around that, or notice just be given in writing, and acceptance of that may happen even if you are silent, and things like that. So it's worth noting. And just because you have rights under other schemes doesn't mean that your contract can't give away such rights as such. So I've just included the example here that rights that you have under intellectual property schemes can be given away when you sign a contract. but we'll talk about that in a bit more depth towards the end of the presentation. We also have express and implied terms. Express terms doesn't need too much explanation. So those are the ones that are articulated by the parties. So whether that's written or oral. But implied terms can actually be incorporated into a contract. So by implication, and courts can make those enforceable. So this can arise in situations where you have a contract and its express terms don't anticipate events that could consequentially affect the contract. So when you go to the courts for a solution, the court may accept that the express terms have some gaps and therefore fill in those gaps with implied terms. Also, as I said, the legislation has a role in certain types of contracts. And so some legislation will imply certain terms to particular classes or kinds of contracts. So terms that are implied by law tend to operate as default rules or minimum standards in contracts of that sort. Again, we'll talk about a few examples of those towards the end. I guess one example that I wanted to include is that when we have standard form contracts, you can have unfair contract terms, and this can sort of work as an exception to the rule that you're generally bound by what you agreed to. So in Australia, we have provisions under the Australian consumer law that apply to standard form consumer contracts. So I won't detail exactly what constitutes a standard form contract, but this are sort of things that a lot of us are familiar with on a very daily basis. So things like end user license agreements, or where we get contracts that are forwarded by one party that have a lot of the bargaining power, and the other party or the individual is in sort of a take it or leave it situation. So individuals, if they notice after acceptance that a term is unfair, or even before acceptance, and regulatory bodies can also intervene here if they know that a contract is floating around with unfair contract terms, you can apply to a court to have a term voided and declared unfair. There are rules about what constitutes unfair. So the court has this sort of three-pronged test that it would cause a significant imbalance in the rights and obligations of the parties. It's not reasonably necessary, as in that term is not reasonably necessary to protect legitimate interests of the party who are advantaged by the term, and it would cause detriment if it were to be applied or relied on. This won't, just because you find an unfair term in a contract, however, doesn't mean that the whole contract will be voided, unless, of course, that unfair term means that the entire contract is unworkable. But you can strike down that term post-application and post the courts intervening. So even if we do have a validly formed contract, it can nevertheless be avoided as a result of a number of possible vitiating factors. Tends to be that most of these vitiating factors are going to involve some form of unfair or unconscionable dealing by one of the parties, and therefore will have the effect of rendering maybe the terms or maybe the whole contract unenforceable. So one of the big ones in terms of vitiating factors as a category is misinformation. And within misinformation, the key ones are misrepresentation or misleading and deceptive conduct. They tend to be sort of two sides of a coin in that they deal with the same thing, but misrepresentation is more sort of court-made, and misleading or deceptive conduct only covers trade or commerce and is created by legislation. One of the most commonly contested parts about misrepresentation is that it is very different from what is the courts have termed as mere puffery. So I guess when you come across like a big advertising campaign with very wild promotional statements, and you rely on that maybe to then buy a good or engage a service, for example, those won't generally be taken as misrepresentation. Depends on the facts of the case. But they won't generally be taken as misrepresentation because those statements tend to be held as they're so wild that a reasonable person would not believe them to be fact, or the circumstances of the advertisement are obviously so wild that they can't be taken as fact. But other than that, untrue or misleading statements that induce a person into a contract can be claimed as misrepresentation or otherwise misleading or deceptive conduct. We also have mistake. So this can be common, mutual, or unilateral. Unilateral is going to be the most common one, I guess, that we incur. The other two are quite rare. Unilateral mistake is where one person is mistaken about some aspect of the contract and the other is not. It is less likely to get a remedy in this case, though, unless there is some sort of improper conduct on the unmistaken party. And when I say improper conduct, it could be sort of actively trying to stop the other party from finding out their mistake and continuing the contract on that basis. Abuse of power is a category of vitiating factors as well, which is maybe a little bit more obvious in that if there is duress, if there is undue influence, unconscionable dealing, or unconscionable or unjust conduct in the formation of a contract, whereby you might put illegitimate pressure down into compelling somebody to enter a contract, exploiting a relationship of influence, or exploiting something about the party in order to get them into a contract. So if any of those come about, likely that the courts will strike down the entire contract and render it unenforceable. And we also have illegality. So therefore, contracts made for an illegal purpose or that contain illegal terms are going to be unenforceable and constitute an illegal contract. So any contracts, for a crime are likely going to be held unenforceable. But this also might apply to contracts whose purposes are contrary to public policy. So a contract for the purchase of stolen goods can be held as contrary to public policy, and the courts might refuse to uphold it. So there are other vitiating factors in addition to these, which are things like lack of capacity or lapse of time. But these are some of the bigger ones. And as mentioned, if any of these are proven, it can lead to remedies for the harmed party. The standard remedy being rescission of the entire contract. So the contract is rescinded and the parties are put back in the position that they were in before the contract was entered into. But it might also be the case that damages are available if parties have incurred costs along the way in the course of the contract being on foot. The breach of contract is one of the bigger ones or more obvious ones that is discussed. And so a breach of contract, it generally occurs where a party has failed to perform obligations according to the terms of the contract. If a contract is breached, the aggrieved party may be able to seek a remedy. So we'll talk about some of the specific remedies for breach in just a second. Important to note, though, that just because there has been a breach of contract doesn't necessarily mean that there is a right to terminate the contract as the non-breaching party. The breach has to be significant or important enough to give rise to the right to terminate, and there is generally no automatic termination of a contract just because a breach has incurred. It has to be a choice and it has to be a positive action taken. So in the event of a breach, we have a number of remedies that might be available to the aggrieved party or parties. One of them is called specific performance. So this is a remedy that is most likely to be used when monetary damages are inadequate to rectify the harm caused. So this might be where the good that was meant to be transferred, is so specific or unique that you can't replace it. And so the court forces through the contract. And this might happen in the case of a sale of land. But there are also a variety of instances where specific performance is not actually an option. So anything where the court has to have constant oversight, specific performance won't be called on, as well as it can't be called on if you are forcing the party in breach to maintain an ongoing relationship with the other party to the contract. So things in like the employment context, you can't order specific performance. The right to terminate the contract is also a possible remedy. So some contracts are going to have explicit terms to this effect, and that was one of the terms we talked about earlier, in that you should know what your rights are and if you have any rights to terminate the contract and under what circumstances through what is written in the contract. If there is nothing there, the general rule is that a very serious breach will give rise to the right to terminate. And to be serious, a breach has to be a term with serious consequences, And by that, that's in the context of the contract. So you're substantially depriving a party of what was intended under the contract, or it is a breach of an essential term. So that when the contract was signed, it's implied that strict compliance with that term was going to be essential. And as I mentioned, a breach of a term or breach of contract does not automatically terminate the contract. It creates a right in favor of the non-breaching party to terminate, but the non-breaching party gets the option to decide whether to terminate, or they can continue to keep the contract on foot and potentially maybe just seek damages for the breach or specific performance to rectify something. So there are options. It's not automatic. And we've mentioned it already, but damages is the big one that comes about as a contractual remedy. So the party in breach can be ordered to compensate the innocent party for any losses from the breach, the goal being to put the innocent party in the position that they would have been had the contract been performed. And in some cases, your contract might stipulate damages for any breach, but if that is not the case, parties either need to agree on it themselves, or otherwise the court will intervene and decide. There are some rules about assessing damages, and this can be things like the damage can't be too remote from the breach. It has to be something that was reasonably expected to come about from the breach, or if it is something unique, it was expected in that context that it would come about if there was a breach. But those are very legal, finicky rules that aren't necessary here. So this, again, is not the full spectrum of remedies available. You can also seek things like an injunction, which is a court order to stop a party from doing something, the opposite of specific performance almost. But this is a sort of general idea. And as I mentioned, damages is going to be the most commonly requested one, or the commonly provided one. So I've already talked about it a little bit, that legislation does intervene in the space of contracts a lot. And so we have specific legislation that applies to contracting in particular professions and industries, which I will give some examples of in a second and how that might come into play for you. But there are things that exist even more broader. So there are potential restrictions on the ability of certain parties to even enter a contract and to deal with certain parties. So, and that includes things like being employed by them. So this might be in the context of large corporations trying to enact mergers and acquisitions that the Australian Competition and Consumer Commission, so the ACCC, denies them or opposes them entering into a merger. And this does commonly happen. And although right now they can't stop the merger beforehand, they can ask the federal court to unwind a merger after it has happened if the parties go through with it anyway. So I guess one example is that last year, the ACCC stopped or opposed Woolworths from buying an IGA in I think a town or a suburb just outside of Canberra. And that opposition meant that the merger the acquisition, didn't take place. So that's a sort of stopping people's contractual freedoms in the first place. Might be that some legislation indirectly impacts your contractual freedoms as they relate to securities on personal property. So there's legislation that you need to register if you have a security over an asset, a personal asset, in order for that to be valid and that to be enforceable. And beyond that, you also have examples of laws that may override contract provisions and that may not be contracted out of. So we have things like the National Employment Standards out of the Fair Work Act. And these are in the employment context, which I will talk a bit about in just a second, as well as I've mentioned, the Australian consumer law does a lot in terms of implying in terms related to the quality of the goods and fit for purpose, which are all going to be implied into contracts for consumers to buy goods and services, as well as they provide in terms related to refund rights and compensation, which also can't be excluded from those particular type of contracts. So the laws do a lot of work in some cases here. So contracts, research, and IP. So how does it all sort of come together, and how does this maybe affect you? So these are some examples of where you might encounter contracts in relation to your careers and your research position. The first is going to be your employment contract, but throughout your work, I'm sure that you'll come across numerous others as well. I'm not going to be going into any specific detail of exact terms across all of these, but I will point out a few things that maybe are commonalities or things to be aware of. Won't be discussing licensing agreements or commercialization here at all, as Tolu will be giving us a wonderful masterclass dedicated to those topics alone next week. So employment contracts, ones that we are all likely familiar with and have come across. So employment contracts quite easily satisfy all of the criteria that I set out earlier in terms of making a contract. So you have an offer from the employer that comes about in the form of maybe a contract that they give you to have a look at. You accept it by signing, and then there you have an intention to create legal relations, given that the employment is a legal arrangement. So there's no questions about that. Consideration coming in the form of you providing work to your employer and then providing wages. So all of that is quite easily settled. But there is sort of more on top of what is even in your employment contract that is worth being aware of. So legislation plays a big part here in that there are minimum standards for all employment that are set out in the National Employment Standards, which are all easily accessible and available online. And those are sort of legal minimum entitlements that we are all entitled to, as well as that sets out that any awards or enterprise agreements or registered agreements also work as minimum standards, that if your particular institution or company has an enterprise agreement, that is also a minimum standard that your employment contract can't opt out of or contract away from. So all employees are covered by the National Employment Standards, whether or not they have signed a contract. I've included pay secrecy here, as this is a relatively recent change that is quite interesting. So as of the end of December 2022, the rules around this have changed, and any pay secrecy terms included in contracts no longer have effect and won't be enforced. So if you but that is for contracts made after 7 December 2022. Contracts that were made before that, if they haven't been varied since, can still be enforced, as in those terms can still be enforced. But then contracts that come about after June 2023 are no longer allowed to have those terms. So you can sort of see how this is a constantly also moving space, and there's a lot that affects your employment contract, even if you sort of assume that your contract isn't changing. And some other clauses that are worthwhile to be aware of. So things like non-compete clauses are quite common in that they restrict employees from working for competitors or starting their own businesses after leaving a job for maybe a certain period of time. It's worthwhile being aware because they can have impacts on the future and your career, and need to be aware of, so they can be tailored appropriately to ensure that they are acceptable. Non-disclosure clauses, so around whether it be confidential information, so preventing employees from sharing confidential information or trade secrets with outside parties, are fairly standard. And then IP clauses are quite common as well. So as we are in an IP and the law masterclass, I will turn to discussing some of those clauses a little bit more. So there are a number of IP-related clauses that may be in any employment contract. So this isn't a comprehensive list, just a few examples. It is probably quite common to just assume what your IP clause is going to be, but hopefully what I'll show here might tell you that it's worth having a bit of a specific look. So ownership of IP clauses are very common in that generally IP created by the employee in the course of their employment will be owned by the employer. And there are sometimes things that are sort of an obligation to sign, so that the employee will sign what is reasonably required by the employer to record the employer's ownership. And this can continue on beyond your employment. So even if you have left that particular job, your previous employer could still come to you for your signature on a patent application, for example. So I just wanted to give like a little bit of an example. So this is just taken from the UQ's open intellectual property policy. And you'll see that in the first clause, that's the sort of standard ownership of IP clause, in that the uni asserts ownership of all IP developed, created, or authored in the course of employment, unless it is otherwise stated in this policy. However, you can also see that in clause 10, it says that the university doesn't assert ownership over IP in scholarly or creative work, so including those generated by HDR candidates. So there are carve-outs, and that's why I sort of say it is worth having a look, as it might be different than what you expect. You'd then have to go look at what scholarly or creative works means, and so on and so forth, but they don't all necessarily take a standard form. We've already talked about confidential information, but that is also another sort of IP clause, that the employee won't disclose any confidential information to any other person or use it in any sort of unauthorized manner. It is important, though, to know what constitutes confidential information, as that can vary from job to job. And then a waiver of moral rights. So we did have Gonja mention moral rights last week, which is sort of an aspect of copyright. I guess as a reminder, copyright generally subsists in literary materials, musical, artistic, and dramatic works, can also be in computer programs in terms of the software. However, moral rights are the non-transferable personal rights that sit with creators of works, and they involve a legal obligation to attribute creators with their work and treat work with respect. The moral right sits separately to the economic right, which is sort of the copyright as such. So even if you think that you hold your copyright, you might actually waive your moral rights, in that you might provide consent for your employer to not attribute the work to you when they reproduce it, and so on. So this sort of plays into the authorship debate. And just as a quick plug, if anyone has received Marita's authorship survey, this sort of relates to your moral rights and your attribution. So please make sure you fill in that survey if you can. And again, just to give an example of the moral rights, this comes into the university's IP policy as well, in that the university recognizes moral rights, because you can't actually fully transfer your moral rights or give them away. However, it is possible that research activities come about and you may be required to provide a written waiver in respect of your moral rights in relation to certain works. So this is also sort of an example of how conditions or terms of your employment can change as time goes on, or more documentation can be provided, and that you need to be aware of what you're signing or agreeing to, even past the first contract. And the final example that I thought I would like briefly speak to are material transfer agreements. So I'm sure that many of you or all of you are more familiar with MTAs than I am personally. However, these are a contract and are probably a common contract that you would likely encounter. And so I've included them here. So the MTA's essential terms are going to include things like the material being transferred, any authorized uses of the material, who the provider is, who the recipient is, and any restrictions on its use. There can also be intellectual property clauses that come out of an MTA. So this can be that the recipient has to, as an example, that the recipient must inform the provider of any IP that comes out of the use, and that the provider may be able to assert a license to that, as just an example. But also worth taking note that material transfer agreements may well be a cross-border contract, and these issues can turn into significant issues because they can relate to the IP licenses, things that might involve significant sums of money. And therefore you want to be aware and you want to be comfortable of what laws are governing your agreement. And so that means what jurisdiction and what courts are going to be there to resolve any disputes. So thank you all for attending and for listening. That's just sort of a brief introduction to contracts from the legal side, as well as what you might come across. I'll stop talking there, but if anybody has any questions, feel free to put them in the chat or to unmute if you would like. Right, well, I've put my email address up there, and I'm sure that everyone has contact with some of the other IP team in the center as well. So feel free to reach out if you have any questions or if we can talk to any of these issues anymore. We'd be happy to, but there are no questions from what I can see and hear. So we'll end it there today. And thank you all for coming along and enjoy the rest of your day.